it will be worthwhile to talk with people who have worked in defined domains. Hi, Kanan. So it's good to see you. So it's like to speak with people who are in defined domains and try to get some direction on issues on which work needs to be done. Because amongst the big challenges for us in doing doctoral work very often is what to do the work in. And if you get even like like a lead or a thread from someone, maybe this is a pathway worth traveling, it then, if it interests you or excites you, you can go further. But if you have to look at a whole domain and then try to work out exactly what is happening there, what is it that you should be doing, and what you want to do there, I mean, it itself can be quite daunting. And very often we find that people make this confusion between a topic of research and a question of research, or an issue worth or a problem worth researching. So in this entire series, we've had, like various people trying to, let's say, provide guidance or at least lead conversation on what is worth doing there. So it's in that context. We had a week's break, and which somewhere I think has got us a little bit off the radar. But hopefully, I've never really felt a very quantitative thing on, it's not just how many people, but it's how intense the conversation is, which makes any conversation worthwhile. And I'm quite certain that Professor Vasanthi, who has been working over a lifetime in the field of labor law, and who has a very passionate interest in the subject, would kind of provide us with just that kind of perspective. What with the new code, what with the manner in which you are feeling that everything which is, is not right at the economic front, if you just squeeze labor, everything will be okay. That seems to be the direction in which we have been headed. And there are a range of very, very problematic scenarios in the manner in which labor law operates. Unfortunately, the way in which we teach labor law or we read labor law, we try to do it through the medium of statutes. Now, statutes are themselves framing the field in a particular way. So when you try to understand the field only through a statute, you go and adopt a perspective without really realizing that that perspective is a superimposed one. You feel, oh, this is the law and I need to know it. But we don't really ask the question of why is this the law, and should this be the law? So I'm quite certain that Vasanthi will kind of, in this entire exposition that she's going to make on reframing of labor law research, would energize us and excite us and catalyze that conversation for why we are having this workshop. Vasanthi is with us here at Nalsar. She's been, I don't want to do that whole introduction thing, and anyway, I do a really, really horrible job of it. So I'll just say that, okay, you have an established expert in labor law who's going to be speaking with you. And over to you, Vasanthi.
Thank you. Okay. Thank you, and thank you all for joining in on this session on labor law. I'm very happy to be able to present this because we do receive proposals on labor law, and one always finds that there is still so much more that can be done, and there is work that is actually happening in labor law that is very different from how most law people perceive research in labor law. So I thought it was very useful and very important for us to look at research in labor law, because we know that this is an area that is researched upon by many other social scientists. So you have an entire department of economics that works on labor. There is an entire sociology of labor, and political science. There is so much of labor that is discussed. But within the legal fraternity, either we believe that it is largely about statutes, and what Professor Dhanda was telling us, that there is so much of legislation on labor that you think that surely this must kind of encompass the entire field. How can we not start with the statute? How can we not look at some of these statutes which in many ways are also constitutions in themselves. So, for example, if you see the resistance to change in the Industrial Disputes Act, you know that almost everyone who works in labor law would say that we shouldn't be changing this framework because it is a framework that has worked. But if we are looking at, okay, what exactly does this do? Why is it such an important legislation? Why does all discussion around labor come around Industrial Disputes Act? Then you realize that the framework of that legislation, in terms of its definitions, in terms of the kinds of, although it doesn't use the idea of a rights based anything, it doesn't say there is a right to strike or there is a right to receive retrenchment compensation or there is a right against unfair dismissals. The entire language of rights is quite strangely missing in the Industrial Disputes Act, but they are actually the rights that are available within the field of labor, irrespective of whether or not any other branch of law recognizes them. So one of the seminal cases on labor law, which is very relevant in the modern context, is when workers went on an illegal strike and the matter was referred to arbitration. And in arbitration, all of you know how the law works. The arbitrator decided that since it was an illegal strike, workers could be asked to compensate the employer for the losses that the employer had incurred. Now, how do you look at this? What kind of concepts would work here? How does one actually approach this question? Because we know that an arbitration is something that both parties have agreed to, and the labor union had agreed to an arbitration, but without anticipating that this is what the arbitration would do. And so now they were stuck with an arbitral decree, and we know that the arbitral decrees cannot easily be turned around. And you had Justice Krishna here, who came up with this idea, but this is an illegality in the law. And what is the illegality in the law? The Industrial Disputes Act does not provide for compensating an employer for an illegal strike, that the framework of the law only provided for certain kinds of penalties, and you can't read in penalties which have not been listed there. So the way in which you frame that question of, okay, this is a matter of an employment arrangement, this is a matter of an economic loss, these are but there is an understanding of power that is implicit when one looks at labor law, irrespective of whether the statute provides it or does not provide for it, irrespective of whether the constitution can actually be invoked here. This is one of those decisions where Justice Krishna doesn't even look at the Indian constitution. Usually what we find is in most of these cases, since there is nothing in the labor statutes, you invariably rely on 21, or you try to rely on 14, or you try to bring in a normative understanding because there's no other way in which you want to understand this particular question. But this was a very interesting case in which Justice Krishna here invokes the history of trade unions, goes back to the first cases on trade unions and says, okay, what is the objective of a trade union? Can we make an assumption that a trade union is directly involved in causing economic harm, or is it only trying to further economic interests? So the manner in which the question gets framed, and talking about the importance of the Industrial Disputes Act, the Industrial Disputes Act was read in a particular way. You could have read it any other way. And that's the need to have the right kind of an approach towards labor law. Because if you start with the statute and say, okay, what is it that the Trade Union Act or the Industrial Disputes Act actually provides for? And if you begin to read the statute by itself, it provides for nothing. There is an entire context in which those legislations have been written out. And if you read the legislation minus those contexts, then there is nothing to read in those statutes, right? So the need to understand where labor law is coming from, how does one approach this question, how were these statutes made, what is the context in which these statutes are made, what is the problem that these statutes are trying to address? Unless we get into those kind of questions, and unless we look at the need to research these, What we are finding right now, the kind of political and economic situation that we are in, labor law itself has become very undesirable. You saw that during the lockdown, in spite of the apparent distress that was spilling over onto the streets, you had state governments which said that we are going to repeal all labor law. I mean, this is unprecedented. That of course it didn't happen at the central level. It was more the central government was more silent about how it repealed labor law, but the state governments were that way more straightforward and said that no, all of labor law gets repealed by an ordinance, and labor law which is not even made by state government, but labor law that is most of labor law, the major statutes that stood repealed by an ordinance were actually central statutes, and no state government has the ability to say that we are going to suspend central legislation in this manner. That's what actually happened in a situation where there was such large scale distress. Now, so the problem here is, how does this happen? How does the legislation which is in place simply stand repealed in this manner? Or how is it that the court cannot or does not answer this question? What are the questions that we need to ask here? What are the various positions that one needs to examine? And this is what I'm going to try to cover in my presentation. I'm going to use 6 illustrations to give you an idea of what we mean by the reframing of labor law and reframing research in labor law. So what I have done is to talk about why we are reframing, and that's what I'm trying to do in this introduction of what is it, why should we frame the question correctly, and what do we mean by reframing? And of course, the more important question of how exactly are we going to reframe? What do we mean by reframing? So I've broken this into 3 sections. So one is that the field of labor law itself needs to be reframed. That is, what is it that we understand by labor law? What statutes come within the definition of labor law? What are the other statutes which seem to have a direct impact, but sometimes are not even referred to as labor law? How is this terrain changing? And how is it that we need to deal with this change, and what kind of research is possible when we are saying that we are redefining the field itself? The other section that I want to use illustrations and explain is what are the concepts that are used within labor law and what is the need to redefine them, particularly if we are saying that the manner in which work is done today, the way in which all of us are sitting at home and working. So the house and the home itself has become the workplace. But this is not so easy, or this is not as it's not a change that is unproblematic for everyone. And how does one problematize this change of there being no distinction between the home and the workplace? Why is there no problem for certain circumstances, and why is there a problem for others? For example, when we talk about domestic work that needs to enter into the domain of labor law, the first question that comes up is, how are we talking about a house as a workplace? But in the entire pandemic, it was so easy for all official spaces to simply declare the house as the place in which work would continue to be done in the same way in which it was done in other spaces. And no employer saw that there was a problem in considering the house as the workplace. But for certain forms of work, we are still saying, but if this is work that is done within the confines of your home, then how is it? How can we talk about this as labor law? How can we redefine the understanding of the workplace to include the home? What does this mean for a whole range of protections that were available in a formal workspace? What is going to happen, for example, when we talk about occupational hazards, when we talk about occupational diseases, when we're talking about other compensations? How does this shift from the formal space to the home, how is this transition for the employer and for the employee, is something that we can talk about. And the third segment, of course, these segments are not so easy to separate out. So each example will spill into all of them. So when we're talking about domestic work or migrant labor, we will say that, you need to redefine the concepts that are used in labor law. You will have to redefine the boundaries of what are understood as labor law or as family law or as criminal law, and what are these boundaries and how these need to be changed. So there is a continuity between them, because one of the first things that I would want to raise through this is, when one talks about research in labor law, you need to do two things simultaneously. And that's something that we've been playing around in the entire series of workshops that we're talking about. That one, you need to set out the field carefully, not too narrowly. So you shouldn't try to get locked up in, okay, am I doing industrial relations, or am I doing wages, or I'm doing social security, or I'm doing X and Y, right? So you when you're talking about work, talking about labor, then the first thing that you need to do is to be able to understand the intersections with various other domains of law. So whether it is criminal law, it is family law, it is constitutional law for that matter, whether it's corporate law for that matter. And recently, I will do one example with reference to some work that I'm doing right now, which is about cine and television workers, wherein the Competition Commission was actually invoked in the context of labor law, right? So how do we negotiate these boundaries between labor law and other legal disciplines? So if you're talking about interdisciplinarity, that is within law, where and how are we locating labor law? What are questions of labor law, or what are other questions which are solved by using a labor law approach? For example, when we heard Prabha Kotishwaran, we saw that the whole question of trafficking or sex work, how does it make a difference, or migration, how does it make a difference when you look at it from the perspective of labor law rather than as human rights or as criminal law or as international law also for that matter? What are the core concepts of labor law that become useful when one is approaching a particular issue? So on the one hand, we want you to be able to look at the problem with its intersections with other branches of law, and at the same time also delineate the problem narrowly enough that you can get into it. Otherwise, the area becomes so broad that you're trying to do everything, which is also something that is not very useful. So while looking at what are the intersections of this particular area with others, you would also then need to narrow down the scope to a particular question that you want to examine within this larger context. So set out the context and then come to your more specific questions. And I hope through the illustrations that I'm doing, this becomes clear to you, and we can, of course, take more questions at the end. So this is the scheme. I'm going to use 6 illustrations. I want to start off with the migrant workers. And then I want to look at the question of the street vendors movement. I want to look at particular sections which kind of exemplify what we are saying about how do you define the field, what are the relevant concepts, and what are the boundaries that one needs to negotiate when one is talking about research in labor law. So when you're looking at street vendors, or you're looking at domestic work, and I said I'm also going to look at the cine and television workers. And if you look at bar dancers as one area in which we're looking at work, and looking at this whole business of what has been called platform capitalism in terms of the new technologies, the aggregators, and the way in which employment relations are being forged in a completely new environment. And so I'll use these 6 examples to try and exemplify these various things that I'm asking you to look at. Okay, to start off with, when we say that there is a need to reframe, what has happened with labor law is that by looking at the plethora of statute, and if you start looking at labor law by looking at the statute, then you completely miss out on how dynamic the field is and how the field is constantly changing and being created. Right? There's nothing static about labor, but if you're looking at statute, then you have legislations. Like, I mean, I don't know how many of you will actually believe that we have legislations which are 100 years old, right? And they haven't been changed. And even if we talk about the new code, it is really old wine in a new bottle. It is just a label that has been attached, and most of it is what is part of the older law. And of course, we try to make some critical changes to do away with the more radical aspects of labor law. So that's the when I'm using that phrase, denuding labor law of its soul, what statute is doing, and this is what comes in by using what we understand as a normative or a theoretical position. So you had the entire critical labor law movement saying, but what statute is doing by coming in here is actually taking away the radical aspects of what is being asked for and making it some kind of a middle way. So if you read the opening lines of the Industrial Disputes Act, also, it is saying that, okay, we are trying to establish industrial peace. It doesn't even talk about justice. It talks about industrial peace, which is trying to come to a settling point or a middle point between two very polarized ends, right? So the Industrial Disputes Act becomes a mechanism to deal with disputes. The underlying presumptions there is that conflict is the model on which the entire law is built, and the law is coming in because there is a need to manage conflict. So if you start looking at law there not as giving anything at all, for example, most of labor legislation, we're talking about bonus, you're talking about gratuity, you're talking about retrenchment, compensation, all of these aspects were hard. Even your 8-hour working day did not just happen. It didn't happen with the statute. It happened because of labor movements forcing employers to agree to certain conditions. So the law, in that sense, is only recording what already substantially labor movements had already established or they were fighting for. In that sense, that the law tries to appropriate this and this entire sense, this entire radical vision into itself, and tries to look good literally and on borrowed feathers. So it is the law is not really actually doing anything but taking some of the credit of what labor movements had already done and coloring itself with that radical vision. And you have this sense that the law is then what is giving these rights, when it is so evident to anybody who looks at it from how did those rights originate, where did those rights originate, that you realize that one needs to approach this whole question of labor statute very, very carefully. So whether one agrees with the critics on this or not, it is a very important insight into how labor law and law itself in this context is a mechanism of co-option, of saying that, okay, you agree to something and I will give you something in return. So if you're looking at the Bonus Act, one very important case, the Bonus Act comes in after you had some very major decisions fought by unions, agreed to by courts, which allowed for a large amount of bonus to be given to workers as a share in profits. And this kind of really set the cat among the pigeons, so to say. It rung alarm bells and said, no, we can't have such large amounts of bonus being given out, even if it is given out in one case. It sets the benchmark very high, and you immediately had a law coming in and saying, okay, what we're going to give you is that not a share of profits when there are profits, but what we're going to give you is a standard bonus every year. Right? So this literally the law coming in and setting in a minimum and a maximum amount of bonus, when bonus was something that would be negotiated between trade unions and employers. So the law literally comes in here to set the field, set the standards, so that unions can't ask for more than this. So setting a cap on what is it that unions can come and do. So the minute you see how law is working there, then you have to be very, very careful when one start looking at statute in the context of labor law. The other idea that when one talks about labor law as the law itself is not radical, it is coming in to take away the radical aspects that are already being established by trade unions and trade union movements, or workers movements, or social movements in other ways. What you also are seeing is that when this law is being taken away, right? And what we are seeing right now, if you're looking at the UP ordinance saying that suspend all labor law, accepting that law which allows for employers to ask for longer working hours, which allows for employers to pay you half the rate. So even the exploitation that we're talking about is happening through the mechanism of the law. So the ordinance sets out that no, you can have a 12-hour working day. The ordinance sets out that you can't ask for anything more than the minimum wage. So we have to be very careful, and we have to examine this very closely to see how labor law comes in there and what exactly is it trying to do, and how we need to allow the law to function for certain purposes. So I gave you an example of Justice Krishna Iyer in the case where he says that no, the Industrial Dispute Act doesn't allow for labor unions to pay compensation because this is not what is provided for by the statute. So there is a way in which the statute can be read in light of particular approaches that one is already taking, whether about the role of trade unions or the role of law as promoting justice, right? So if you're approaching that in spite of whatever poorly worded legislation we have, all of this legislation will be read in the light of what we talked about as social justice, then even this law could be used to meet certain ends, right? But if you remove that entire that entire normative framework in which the law is going to be placed, then the same law can be read very differently as a means by which you are going to enforce conditions of exploitation, right? So I hope when we are talking about why framing labor law becomes so important, this is something that I have been able to explain. So the second point that I have put up there, which is that in the current, what is referred to as the political economy, and what is the political economy that one needs to refer here, then one says that, okay, the predominance of what we're talking about as a rights-based approach also has its very dangerous propositions that one needs to be very careful about, right? So when we say, okay, labor law is undesirable, and why is it undesirable? Because it restrains people from, in that sense, self-exploitation, or it restrains people from entering into whatever contracts they want to enter into, right? So the argument of autonomy and freedom is made to say that, okay, now people are free to enter into whatever contracts they want to enter into, and we are going to assume that all contracts that people are entering into, they know what they're entering into, and so then the other questions don't become relevant. So, and this kind of underlies the entire idea of why labor law becomes undesirable, because how are you portraying labor law, right? If you portray labor law as a restraint on freedom to contract, you say that it is labor law that is not allowing you to enter into contracts which allow you to work more and get more payment, or which doesn't allow for the individuation, right? So labor law is traditionally known as something which locks people into certain categories, right? So the classification that we're talking about, or the way in which labor law statute in India particularly does the classification, is like very, very problematic. So it classifies the higher paying jobs as something that labor law is not directly concerned with. So labor law says, oh, but I'm only going to deal with X, Y, Z category of persons, and the others either don't fall within labor law or fall within labor law for certain purposes only. Like the Gratuity Act applies to everybody across the board, but the Industrial Dispute Act applies to only certain kinds of workers. So this classification within the formal sector, and of course the entire classification between informal labor, formal labor is again a problem. But this classification that labor law does, as a result of this classification, it breaks up people into certain categories and doesn't allow for a manner in which you raise a question as a question that cuts across with various categories. So then you say, okay, workers for certain purposes, workers under Industrial Disputes Act have this, other workers don't have those kinds of freedoms. Workers who fall within the ESI have this. So the fragmentation that you see there, which is a result of the statute, what has been deliberately done, that even these new codes, while trying to bring all of labor into particular codes, is still not able to cut across these various categories that we are creating by the law. But in spite of this fragmentation, one thing is very clear, that labor law is undesirable. So you make labor law into a caricature. You denude it of its radical content, you remove its normative basis, and you say, okay, but do you know what labor law in India is? Labor law in India is saying that you need to provide for drinking water in earthen pots, and that's labor law in India. I mean, they reduce it to the worst form of rule making that is there in the statute, and then say, do you really need this, right? In an age of air coolers and water coolers, I mean, here you have a statute that talks about having water in mud pots provided at a certain distance, and having toilets of this size, and canteens of this nature. Look at how irrelevant the law is. And so let's dismantle labor law per se and allow people the freedom to contract. So this calls for a very deep engagement with what are these foundations on the basis of which these arguments are made, and how one has to work with those concepts and just look at them more carefully. What is the idea of freedom that you are working with, and what is the reality, and what are the real choices that people have? Do they have any choice when they're entering into these kind of contracts? How does one reframe these fundamental concepts within the idea of rights, whether it is freedom or its dignity or its choice and autonomy? How do these need to be reconceptualized? That's something that I will come to, but I hope the idea of why we're talking about the reframing, what is this idea of reframing, is clear to you. So let's look at what we said. Why we're talking about, or what are the ways in which you can talk about redefining the field of what is labor law, right? And why you need to move beyond what we talk about as a formal contract of employment. Why do you need to move beyond this classification, right? We said anybody who studied labor law would be very familiar with, who the definition of workman being inconsistent across labor statutes. There is no single idea of course, it's a workman. We are still talking about labor law as something which is so gendered in its language that either you believe that it doesn't matter that there are women there, or that the idea of a worker, in spite of the fact that it's very evident that the worker that you're talking about has to be male, given the kind of circumstance, given the conditions in which you are assuming that work is done, and everybody else who doesn't fit this model ceases to be a worker. So if your idea of a worker, and one way in which one can look at this when we're talking about redefining the field, is to say, okay, what we have understood as pure labor law, right? Now this idea of what we refer to as pure, and I'm really using inverted commas here, the idea of a pure labor law is the law wherein you have an industrial worker, and you have the capitalist class, and you have a situation of conflict between a clearly identified employer and a clearly identified worker who need to negotiate, who need to work together, who need to cooperate to create something. And this is the understanding of industrial law. So, this idea of a pure labor law confines itself to only certain forms of work and certain kinds of workers. And particularly in India, and this is something that has come through only by research. So when one is talking about how research contributes to redefining the field, you had this phenomenal work by the Association for Unorganized Workers, this the what is understood the Shram Shakti report, which is a report on self-employed workers and women in self-employed work, that you saw that most of the understanding of what we talked about as work is largely inapplicable in India, particularly post the 1980s. It was always implicit, but with this report, and this was the research that was done by actually going into the field and talking to women and saying, okay, what are the various livelihoods that women are engaged in? It busts this myth of the idle housewife, to say that most women were either economically dependent on the man. Most women were not finding their own were not engaged in economic activity, and that the only people who were engaged in economic activity were men. And we were only going to count the men, and we were going to count the unemployment among men, but you really didn't examine the various ways in which women were engaged in livelihoods. And the first study, and this is where you can't think of doing labor law without engaging with any particular field, that even if you are doing judicial interpretation, even if you're only looking at statute and you want to only look at court cases, it becomes absolutely imperative for you to examine the field in which these situations and these claims are coming from. And if you don't do that, then you have a very, very narrow view of what is it that you're trying to set out to. So this is the first time that you broke open this myth of the industrial worker as being the only worker deserving the protection of the law. But of course, we didn't know how to talk about these new forms of work. We didn't know what is it that needs to be defined as work now? Who is it that we need to define as a worker? And what are claims that can be enforced against the employer? So while this opened up an entire field of work, in terms of statutory changes, it was much more difficult to work with them because of the premise embedded within statute that we need to deal with only workers in factories, and everybody else is not really part of what we need to deal with is labor law, right? So if you're looking at statutes on labor law, you will not have something like the Narega as part of labor law, right? You don't, and if you're looking at these new codes, you don't even have something like child labor and bonded labor as part of labor law. So what is it that we are going to define as labor law? So when there is so much talk in the context of the migrant worker, that one is talking about the Interstate Migrant Workers Act, but how can you talk about the Interstate Migrant Workers Act without referring to the Bonded Labor Act? Because this migration that we are talking about is migration under a contract where people have been paid at home or they are working to repay a debt. There is no way in which you can understand the Interstate Migrant Workers Act without referring to the Bonded Labor Act. And these are changes which were brought in the Interstate Migrant Workers Act to say there is a connection with the Bonded Labor Act, there is a connection with the Contract Labor Act. But when we are saying that all of these other statutes stand overruled, we don't even realize that it's impossible to do away with contract labor and bonded labor and still have migrant labor. And this is where, how are you defining the field? What are you defining as the field becomes very important. So to do my first illustration, to talk about migrant labor, right? So, and I thought we will just pick up the decision of the Supreme Court, the recent Supreme Court judgment, and say, okay, what is it that the court was trying to do here? And you saw that court was engaged with questions of, okay, you had this large scale distress. People didn't know what to do, and so they were going back home. And this relationship of what is the home and what is the work, and all of these questions is something the court simply ignores and simply says, okay, we need to provide for ways in which people need to go home, so let's have trains to transport them home, right? And let's have food that is arranged for them. Now, not for a minute are we saying that these are not important concerns. They are very, very important concerns. And that's where the field of labor law is impossible to separate from something like food security, and something you can't separate it out from, your ideas of freedom and the right to move and the right to travel. You can't separate them out at all. But if it says, okay, what is the pure labor law question that was here that needed to be answered? The pure labor law question the court is very well aware of, which is that the minute the lockdown was announced, under the Disaster Management Act, the government had said that employers are prohibited from removing their employees from work. That was a pure labor law question. So when one is talking about redefining the field, one should not lose sight of what are the important questions which are not being answered. So the court, we all know, right? Anybody who's following the litigation knows that the employers federation reached the Supreme Court and said this is an impossible law. How do you expect us not to send our workers? How do you expect us to continue to retain workers, even if it is for a short period? Even if it is just say, okay, use the Industrial Disputes Act to retrench workers, to lay off workers, but give them something so that they can go home. Give them some kind of a severance pay. You pay up whatever was due to them, even if it's a smaller question, even if it is a simple question of what we talk about as pure labor law, that is just the provisions of the Industrial Disputes Act, to say that you have to give them severance payment. Even that employers asked for an exemption from, and there was no exemption given, but you saw the OUP ordinance saying that, okay, all labor law stands suspended. And so these are not required to be done. And you can enhance working hours, which is violative of the Factories Act. And you can reduce pay, which is violative of wage agreements that you already had, right? So how one understands the question. So the Supreme Court, when faced with what is a pure and hard labor law question, which is that there can be no mass removal of workers. This is something that industrial jurisprudence in India laid out years ago. You can't have mass removals. What you can have is, okay, there will be phase-wise retrenchment, and there will be some amounts paid during retrenchment. Or if you don't want to retrench them, then there have to be layoffs, and still there are some obligations which have been written out. Nothing is invoked, right? Only legislation that is invoked is the Interstate Migrant Workers Act, and in the Interstate Migrant Workers Act, there is a provision, and all these migrant workers are workers under Industrial Disputes Act. So the interconnection between the statutes, anybody who knows the statute well enough knows that they are interconnected. There is no way you can separate out these statutes. But the court only focuses on the Interstate Migrant Workers Act, says, okay, under the Interstate Migrant Workers, these workers should have been registered. Nobody bothered with registering them. Of course, it had some very unpleasant things to say about the government, which were well reserved, but still, from the perspective of labor law, it didn't answer the hard questions of termination. It didn't answer the hard questions of how employers were allowed to completely not follow any of the mechanisms that were already in place. The small mechanisms, even for the formal workers, were not in place. Right. So the first question. Second, what is this? What is the definition of a migrant workers? Are these self-employed workers migrant workers? Are workers who work in various ways through the city, right? Everybody who was working home was not an industry worker. So what were the livelihoods these persons were engaged in? And when the shutdown was there, what are the obligations that are owed? This is a new form of labor that needs to be addressed, which can only be done by engaged research, right? So the migrant labor situation shows us how we need to understand not just formal but informal labor, how you need to understand not just the statute but what's left out, how you need to understand interconnections between the statutes. That takes me to the second example of the street vendors. Right? The National Association of Street Vendors was an association, and they say that they registered themselves as a society, not as a trade union. Right. So here we have you have a new formulation that is being used by workers to claim, when they filed petitions in the Supreme Court, they filed petitions in Article 19, claiming themselves to be entrepreneurs. Right? But it did not mean that they dissociated themselves from trade unions either. So the trade unions, which were a part of the association, were allowed to continue, but they also they created an identity for themselves that talked about having a new kind of a relationship with the government on this area. Right? So you have the Street Vendors Association, which was engaging with very different questions. And this is the second point of what, when we're talking about, you need to talk about the concepts very differently. The question with reference to street vendors is what is seen as a public place, and who has the right to access public place, and under what circumstances do we talk about accessing the public place. So here you had a new formulation, and there was a lot of research that went into it, that went into understanding how we need to talk about public spaces in a particular way, how the street vendor can't be criminalized, what were the mechanisms by which you talk about street people who are working on the street as being illegal, as being encroachers, as people who need to be evicted from that place. What is the dynamic between the formal shopkeeper who doesn't want this person sitting in front of their shop, and where you have shops which have the workers sitting in front of them? What is the relationship between them? So these categories that we have created between formal and informal, organized and unorganized, as if they are watertight compartments, when you actually see it on the field, you find that one is feeding into the other. The entire army of self-employment that is created when formal work is being outsourced out to a whole range of people to do within their homes. But the work is what was earlier done in a factory is now being done at people's homes. So do we say that this is no longer labor, and they are no longer workers because their relationships have changed? So each sector that we talk about requires its own conceptual apparatus, while perhaps drawing upon some of the ideas that labor law in its origin was working with, right? So the idea of economic subordination. Now, why would you talk about self-employed persons as workers, right? So if you are working with this idea that what labor law deals with is economic subordination, then you can talk about other forms in which this subordination is happening, and use the idea of subordination when one is talking about areas such as street vending, right? So this is the second example that I thought with which we can move into what we talked about as concepts within labor law, right? So what is this understanding of an employment relationship? Who has an employment relationship? How do we define an employment relationship? Now, the third example that I was talking about, the street vendors, is one example in which we talked about the idea of subordination as being relevant. The third example wherein we saw a new kind of work, that is, if you're talking about Uber drivers, and if those of you who've been following the litigation know that whether it's in France, it's in Italy, or it's in UK, it's in the US as well, that people who were working for these aggregator companies, that is Uber and Ola, were claiming that they should be understood as workers and that they should be paid minimum wages, because although the promise is that all of them are making way more than what the minimum wage is, it is not true across the board. But the companies went up and said, but where is the employment relationship? I have an app in which you have a customer who accesses the app, and you have the driver who is accessing the app, and they have a relationship between themselves. I am merely a platform, and I am not creating anything here. I'm not controlling anything here. So you had this concept of alienation, which is quite different from the traditional alienation that Marx was talking about. But here, the alienation concept was used by the courts, whether it is in Italy or in France, to talk about how the worker, the driver who's accessing the platform, in that sense does not have any control over the route he's taking or the customer, because there is a limit to how many customers he can refuse, and whether he can refuse it or he cannot refuse it, and what are the conditions under which he enters into a contract with the aggregator. And the court found that here what you're seeing here is that the aggregator is actually able to control the employee in a way differently from the way in which it was done earlier, but there are still elements of control and the element of alienation which allows us to understand them as workers, right? So here you again had an entirely new set of people who were making what we understand as pure or traditional employment claims, saying that I must be recognized as an employee, and I must be recognized as an employee just like I am recognized as an employee for other purposes. So here you have various people who want to be included. So in the new labor codes, one of the ways in which they've just defined it, not done too much about it, is to say, okay, there is something called a gig worker, right? And this is a new definition that comes in, which is trying to bring in persons who were outside the domain of what we would talk about as labor law, that is a factory worker, industry worker, that you have to work at a place which is controlled by the employer for you to be understood as an employee. And this means that the field is changing, the concepts are changing, or at least the concepts are being redefined, right? And whether one talks about emotional labor or workplace democracy, these are new ideas coming into what we understand as traditional labor law, and saying, okay, how does labor law account for discrimination, for example? Or how does labor law account for the emotional labor that people need to put in when they are coming to work? And how does it deal with those particular ideas? Are newer and emerging areas which are redefining what we understand as labor law. Let me then take you to, are you able to see the PPT? Let me take a break and ask people if they're able to hear me and see me. Yes. Is the slide moving? Is the slideshow moving?
Yeah, it is. It is.
Okay. Should I conclude the next 10 minutes and then we'll have questions?
That'll be fun.
Yeah. Okay. I'll just go through the other examples that I thought about. So when we talk about redefining concepts, one of the ways in which we talk about redefining concepts is to say, okay, there are two ways in which concepts may be redefined. Like I gave you an example of both the ways. I thought I'll just make it clear about how we look at this. One is where you build social movements, like you had the street vendors movement that built an entire movement to get the law to start recognizing certain forms of work, right? And in certain pockets, you also had this, and you had legislation specifically made for them. You had the building and construction workers, you had the tea estate workers, you had the plantation workers, you had the BD rollers, women who were engaged in rolling BD. So at various points of time, you did have social movements which forced the law to engage with this whole question and have and change its concepts. But that works for some sectors. It doesn't work for the others. For example, domestic workers have been litigating forever to try to get to break through this, but they are left out of most statutes even today, right? But the other way in which you talk about adjusting labor law is what I have said, that you use whether it is Justice Krishna's judgment or it is these decisions of the Italian Supreme Court, where they used certain concepts, they used interpretation to change the meaning of certain work arrangements, right? So this is one way in which you talk about these adjustments being made to labor law, which disrupt the existing understanding and give way to a newer one. But one other idea that we talk about is that the labor law itself is a disrupting phenomena which disrupts the status quo that is in place and tries to create a new idea. So if one works with this understanding that labor law has a certain core, has a certain set of ideas which can't be conflated with, let us say, contract law, and you can't treat an employment contract the same way as you would treat other contracts of employment, then you begin to recognize this field in terms of certain ideas, certain concepts which are particular to this field, which are to be used. So for example, if I use my cine workers example, then that is an example wherein you had trade unions that operated within the cinema industry. So you do have what are understood, for example, one of the largest trade unions is the Western India Cine and TV Employees Association, right? Which is a registered trade union, which enters into collective bargaining with the Film Producers Association, right? And but whether we can call this a collective bargaining agreement, because the Industrial Disputes Act was never invoked. Nobody went to the conciliation officer, invoked his jurisdiction, although the trade union was registered, but nobody invoked the Industrial Disputes Act. So whether is this a collective bargaining at all? Because what they entered into was a memorandum of understanding, an MOU. And this MOU set out all the conditions of employment, similar to what we were talking about, which is that you have a call sheet which is for 12 hours. You can't ask for wages beyond what is being agreed upon. You have absolutely no safety requirement. Very clearly, the memorandum of understanding says that if there are any accidents, then the respective trade unions will take care of that. The film production cannot be in any way disrupted. The film production cannot in any way be called upon to discharge any obligations other than those specifically mentioned in the MOU. So at one level, sure, it is a collective bargaining agreement. But at another level, it is not a collective bargaining agreement because there is no understanding of a right that is being asserted here. It is more like a group employment contract that was thrust upon people, and everybody was expected to run with it. The only clause that the workers union tried to bring in is to say, okay, if you're working in Bollywood, or you're working in the Western region, then you have to employ people, particularly at the lower level, whether it is your lightmen, your junior artists, but not the big stars, of course, the lightmen, junior artists, dancers. There are a whole range of people who are involved in the industry. These people should come from that region. You don't import people from outside the region. And this clause, the Producers Association took to the Competition Commission to say that this kind of agreements are against free competition, because you are not allowing for us to use the best resources from wherever they are, right? Now, and in this context, you had the Competition Commission, which did not base itself really on an understanding of labor law, but invoked the entire domain of what is competition, what is fair competition, and said that yes, of course, contracts like this are against competition. And while we understand that trade unions are involved in wage setting and protecting labor, but they cannot impose conditions like this. But this can come in by law, right? Now you know whether it is in Maharashtra or it's in Andhra, you're talking about reservations for locals within the law. But this can't come in by way of a MOU, and that would be against competition according to the Competition Commission. So here, if you invoke labor law ideas, then you have a very different understanding. And when you're using ideas that are coming in from a different field, then there is a need to balance out both of these. So here, the idea of industry workers requiring the protection of the law, requiring that the MOU, which operates as a law unto itself, needs to be understood from a particular perspective, because in other circumstances, we know that collective bargaining agreements have been held to be better than Article 14. For example, those of you who know the air hostesses litigation know that a collective bargaining agreement was justified to say that if you're asking women to retire at 35, it is okay, because after all, Article 14 can't be more important than a collective bargaining agreement which people have voluntarily entered into, right? So this is where you talk about labor law, by identifying its core aspects, can become a disrupting phenomenon in itself. The reason when we talk about redefining concepts, or why we need a theoretical approach, is that is there something very intrinsic to the nature of certain employments, that this is employment and this is self-employment. And this is something that was raised in the entire Uber drivers case, that how do you define, is this work that of driving a car? Can you talk about a driver who intrinsically would be self-employed, or who intrinsically is being employed by somebody else? Or are these creations of the law? That is, if you define if you understand, look at your definition of a worker, it is how if you have entered into a contract of employment with somebody else, then you become a worker. If you enter into a contract for services with somebody else, you're no longer a worker, but you are a self-employed person or an independent contractor. So these are legal creations by which you talk about something being employment, not employment, and there is a need to re-examine these, and you look at the continuum between workers rather than try to slot them into particular categories. And as Professor Dada was saying, I've been working for 20 years in this, so I will never finish unless I tell myself that I need to stop. So what I will do is perhaps give a last illustration of how one looks at, there is a need to search for a normative code and understand questions as right. And one of the examples that I want to talk about was the bar dancers case, where the question of looking at forms of work and persons who are doing them, and how gendered notions of looking at that work allows us to take very moralistic stands and take stands which are very different. And if you look at these questions as rights, in which the way in which the Supreme Court looked at it as a right under Article 19, how does this change your understanding of certain questions, though they may be employment questions? When you invoke rights in a particular way, is that one way in which you're able to offset the otherwise gendered questions that come into these forms of work? So that's one area in which we found that being able to draw upon the entire field of gendered work, that you were able to answer the question otherwise than the way in which it was framed by the state. The state simply framed this as a question of protecting women, without engaging with the idea that these were women who were engaged in an economic activity that allowed them to survive, and you frame it as an employment question, you frame it as a rights question. How different do certain questions look like? To look at certain other previous presentations, we did examine how Prabha Kotishwaran was talking about the entire idea of trafficking and the way in which criminal law is being challenged by saying that isn't it better to understand these as questions of labor law rather than as questions of criminal law. So I think my last slide is to just draw upon some of the questions, some of the themes that the earlier speakers in this series have talked about, which are relevant for labor law as well. One is to look at social history of labor law. Like I said, the Indian Trade Union Act and the Indian Industrial Disputes Act didn't come to cater to Indian workers. They were created because of pressures from British trade unions, which said that Indian capital was able to exploit its workers in a way in which British capital was not able to, and you were able to create and generate products here which were in competition with European products without the associated costs. So the law came in as a need to impose some responsibility on capital here, not from the point of what are the needs of labor here, which is why you only have those kind of statutes which deal with industrial labor. If you took a hard look at what Indian labor is, and you have a whole, at least 50% of labor is agricultural labor, for which we've never made any law at the central level at all. The other thing that was touched upon earlier is let the field speak to you, because otherwise you get a very, very static idea. You get an idea that this is law and this is statute that is extremely difficult to try and understand, and it's an area which offers very little in terms of any kind of an excitement. But if you just look at the field, if you take up any small section and try to let the field speak to you, then there is no way in which this doesn't become a very dynamic and a very exciting field to work in. So again, something that Professor Danda spoke right at the beginning, please try to pick something that excites you. Even if you don't know everything that is there to be known about it, you will learn, because the idea excites you. So although labor law looks huge and it has all these various facets to it, but if you're excited in a particular area, then pick it up, and then the way in which you can do your reading and you can do the other way will flow. But start with something that speaks to you and allow for the area to speak to you, and then you get a very different sense of it. Idea of what Professor Mustafa was talking about, don't keep it judge centered and don't keep it statute centered, but look at who are the litigants, look at what is the larger political economy here that you need to engage with, what is the place of these people in the larger society, is something that I thought are ways in which research can be framed to do very exciting research in labor law. Yeah, and with this, I will stop sharing. Thank you all for listening to me so patiently.
Thank you so very much, Vasanthi. I really found your presentation to be very fascinating, and I think somewhere, if I had to capture it, to a large extent, what you were saying is that very often we kind of make our entire examination of labor law as very law centric. We begin from the law and we from there talk about labor. Whereas what you did for us literally was that you moved from labor, you looked at the whole realm of work, and then sort of spoke of that, see, how does law address this? And it is like there are these whole range of issues which are not addressed by law. There are categories which are superimposed by the law. There are connections which are naturally there, but you are artificially severing them. And there are connections which you are artificially making, which you should not be doing. So it's like when you start looking at not from the lens of the statute and the case law, you suddenly find a very exciting field before you. The kind of questions which leap up are of a very different order. And I do think that I'm hoping that as a follow-up to this, and we need to have possibly amongst the, not the very first one, but amongst the first level of workshops that we should be doing as part of our faculty development program. And we've got, even the people who are joining these workshops, whether in person or where subsequently when they look at recordings, many of them are also teachers. They are teaching somewhere or the other. And I actually do think it may be, I'm literally putting it as, and because we are a smaller number, I'm not literally going off into break. I'm just wanting us to, because we can have these one-on-one conversations. So I think the model for this workshop can be trifle different. I really wanted to, and I'm hoping that other colleagues who are here, Kanan, Philos, Manisha, Ikshita, I would really want you to think on this. But you think amongst one of the things that we really need to do to energize research in labor law is to alter the way we teach labor law. It's like through your entire LLB, even if you have labor law coming in as a specialized paper in the master's program, that that paradigm of going from law to labor doesn't really change. You're all of the time giving this very dominant position to people will break their heads on, with the Bangalore water supply and what it was doing, and its definition of industry. And in some manner, that artificial construction so takes you over that the larger questions of that, okay, listen, what was this statute doing? Not what the case was doing, not what the judicial decision was doing. Because evidently, see, what Desai tried to do in his entire jurisprudence was to turn labor law on its head. He was trying to sort of, in some manner, empower the workers. And all the criticism that his judgments received and all the reversal which happened was because that larger question of the field never got foreground. It kept becoming, but this is not what the statute is saying. And if the statute is not saying this, then the judge, in doing what he's doing, is taking over an entire field. So I really do think that it might be, because it might be a worthwhile thing. We have, like in one of the students who's registered with us and who's wanting to look at innovation and legal education. I genuinely do think that these are questions. Can you? Because it's very difficult. I'm hoping that those of you who are here will respond to this question of mine. That, do you think the kind of resistance and the sort of absence of imagination comes from the fact that you're so strangleholded in thinking about labor law in a particular way that to break that classification and to start anew becomes very, very difficult. So maybe amongst the first things that we need to be thinking about is how do we change the way we teach labor law? How do we change the curriculums? And because see, you just look at what you, when you spoke about reframing, and then let's look at the curriculum of labor law in any law school. Whether the more traditional one or the national law schools, or even like what you were yourself compelled to very often teach. And if that's the way in which we are having conversations, is it really possible suddenly to have people change gears and say, we are going to be doing labor law in this very dramatically different manner? How much receptivity or how much of discomfort? We push people out of comfort zones, it's true. Part of doing research is that you get out of comfort zone. But it's also like at least some level of familiarity in this other world exists. So I wanted to start this conversation from there, because I felt every one of the examples that you took, right from looking at the concepts again, looking at the field, looking at whole ways in which work is happening and how it doesn't get categorized as work, or even if it gets categorized as work, it's not seen as a question of what you call pure labor law. And because it's not seen as a question of pure labor law, you push it out, you sort of you say that, okay, this isn't something that has to be discussed here. We can discuss it maybe on social justice platforms. We can discuss it as a part of constitutional law. We can speak in terms of how possibly for economic advancement and development what we need to do. But and I thought one very, very, I'm in a way recapitulating what you're saying, but I also feel for discussion that's important. I thought a very important point you made was the distinction between the whole realm of contract law and labor law. And yet that connection and disconnection is something we don't talk about. My second, I'm sorry, but I'm also sort of like somewhere trying to think on why is it that the traditional areas of law we don't feel these are issues to be researched. Because amongst the things that Kannan has had a huge problem with all of legal research, his thing somewhere is this, that it's like policy questions that people raise. They'll pick up a legislation, they'll say this is what it is doing, these are the additional things that it has to do, so no core questions get really asked. And because we don't teach like that, then consequently we don't think like that, and we don't research like that. So that would be my, at least my first throwing open question. And I would, before Vasanthi responds, I'll invite other people to chip in, because I want us, like that we've all taken time and we're sitting in here and she's given us this amazing presentation. Let's think from this angle that this is going to be made available online, and the recording should become that much more thought provoking for people. So how let's say how energetically or how imaginatively we discuss it here, the importance of what we are doing here becomes that much the greater. So let's keep the absent audience in mind, but let the present audience fully participate. I'm really inviting everybody, and I hope that maybe, Kannan, I have provoked you to speak, to respond to what Vasanthi has done, and then I'm encouraging all the others to also do so. Yes, hi Kanan. I think I quite like your t-shirt, and this is like, okay, what is the dress code for working from home?
So I think the participants, if they start asking this question, if necessary, I will also
No,
join.
no, no, I was somewhere wanting you to just respond to that one point, which is your constant quarrel with all of us as law people, and the kind of proposals which come from. Because I think Vasanthi framed it very, very differently, and I think went to more core questions, the sort of questions that you're constantly pushing people to ask. So I was wanting to asking you to respond from there, and then of course I'm, going to have Vetha and Dikshita and Anisha to sort of chip in. Uh,
Yeah, yeah, I think today Dr. Vasanthi has taken up a lot of empirical examples and try to address that within the kind of legal framework we have within the existing structure, and also trying to ask some kind of conceptual question regarding labor. And it is true that I always feel that law teachers, the way they understand the linkage between the text law, the textual law, and the society as a text. So there should be a kind of interconnectivity, and that is the way we, as a social scientist, we try to look at this. In that sense, I think she was trying to link the text and the social text, and the examples she gave was very good. But one thing that I just even wanted to ask her. Uh, First of all, I think when we talk about labor law, and there is a huge difference in understanding labor and the work itself. Uh, Conceptually, they are Marx himself differentiates it, and most of us we take labor as economic productive work. So economically productive work is different from the labor, and the way legal domain understands labor, it looks like sometimes they understand labor as a mere economic productive work, and sometimes they try to understand labor as something, a kind of a social life which exists beyond the economically productive work itself. Because for Marx, labor is not just mere economic. For Marx, labor is a social living. It's almost like an existential question for Marx. Therefore, he takes enormous effort to, bring out the agony, the suffering of labor in the capitalist context. But I think the Indian uh, lawmakers when they were, because I remember when I was with Ford Foundation, what which Professor Danda was doing earlier. Initially, I was associated with that. We had a national level meeting also. In that, what one thing which really what I said is that the way the labor is understood by the establishment and the legal domain, the way they understand it is almost there is a kind of a, the legal system, the court and the lawyers, the way they understand the labor is almost like what the labor is understood by the employers or the industries, and there is a kind of a close connection between them. And what is left out is the labor which Marx was talking about, and how labor law is often understood as a mere problem, because many of the economists who are working with the World Bank or various other groups were saying that India is facing a lot of issues in its uh, big industries. It's because of we have a labor law, which is stringent labor law, which is even you know in a sense which is even strict, or which is more compassionate, which is more which takes care of the labor. Even the China, even Soviet Union did not have that kind of a law to protect labor. But what we see in the recent past is, as a part of the liberalization of the economy, they are consistently compromising on the protective measures which we have it in the labor law. It started with the Rajasthan government started implementing the labor law, modifying it, and ultimately just they are listening to the neoliberal economists to try that if you amend the labor law, we will have a huge, we'll have a good development, or we will have a good growth in Indian economy. So I think that is happening. So if you ask these kind of questions, I think the where exactly I would look at is that is this kind of labor instruments we have, whether the labor law understands it as a labor, in what sense it understands it as a labor, or it understands in what sense it understands it as a work. And so this kind of a things it's very important. She was Dr. Vasanthi was referring to the work, the way the workspace is uh, workspace is a factory, workspace is differentiated from the home. But I think capitalism consistently negotiated with the workspace and home, especially even in the early part of industrial capitalism. Not now that we are sitting in the late capitalistic context. Even in the early capitalism, I think capitalism understood the home also a workspace. Okay, not just it happened now because of pandemic situation. This home also workspace, because we have something called household work, where most of the women work and the child labor is happening. The household work was a huge invention of capitalism to exploit the labor force, and also to create a labor army to really. I think those kind of questions, how the labor law would be, how they will understand it as a mere work supporting the economy, or it is a labor. I think some of the deeper theoretical questions, if you pose like that, then I think the labor law which we have, how important they are, and what level they are understanding the labor, and those kind of work I've never seen student doing it in Indian context. Probably in England, probably in Germany, maybe some scholars might have done this way. But that's what I thought I should tell after listening to that. Thank you.
Yeah, thank you so much, Kanan. Can I ask the others to sort of chip in? And of course, you don't have. I'm sort of setting it up more as a debate and a conversation. But if you have specific questions or anything which is bothering you, you're welcome to. But I'm sorry, like you're going to be in a bit of a spot that because we are a smaller group, everybody has to chip in. Yeah, Vetha, I can
Good.
call of.
Good afternoon, ma'am. Thank you, Professor Vasanthi. When I was listening to the presentation, I kind of saw some similarities between how you conceptualized public law in our comparative law, public law classes, and how we were conceptualizing labor law. So, one query which I had was we identified in public law that the core concern which public law engaged with was questions of legitimacy. So, on a similar vein, I was wondering what you would identify as perhaps the core question that labor law deals with. So I was just wondering about that.
Manisha Dikshita, do you have something? Otherwise, we could sort of like Vasanthi could respond to Kannan and Vetha and we could then come back. Or me, I also raise questions.
Yeah. Do they have questions? Yeah, Manisha? Okay, so I think what I will do is
Uh, Professor, I think you've muted yourself.
yes, yes. Sorry, I'm muted. Yeah.
Ma'am,
Yeah, Manisha.
good afternoon, everyone.
Yeah.
Ma'am, like as you said that like the labor law statutes, they are sort of reducing labor law, the content of labor law to certain particular things, and similarly how the judges are approaching certain cases like the dances case, where the question of employment or labor law was not being like answered in the context of labor law. But and however, when we are like how we have been taught labor law, it's quite different. And like we usually focus upon only legislation, and we are not introduced to this side of labor law or any other law, how we have been like how you have been introducing it to us. So sometimes it's like it becomes quite overwhelming at at one point that I like I really don't know how to start if when we are focusing upon interdisciplinary things. So, but like, how should I start or where should I start? Because even the judge, even the judicial precedents and the legislations are not looking at them in the way that you are asking us to uh, read them. Yeah.
Thank you, Manisha. So I will respond in
Yeah,
terms of
yeah,
the
all right.
sequence in
I
which.
think Dikshita has a question too. She's saying, if you look at the chat box, she's saying, can a study of on women migrant workers, especially during this pandemic, be a good area of study? Okay, that I think that's something we can look at subsequently. You answer the more larger question, then we can. Uh, Dikshita, one of the things which I would want to say before Vasanthi responds, amongst the things that one is trying to get you to think about is don't think in topics. This question is thinking of a topic of research. It's not thinking about a problem of research. I mean, I would somewhere say, like, think back to all that Vasanthi has said through the morning. She's somewhere asking you to raise some very fundamental questions in the whole relationship, say, between the employer and the employee, between worker and the let's say the people who are hiring the worker, that entire connection, the relationship, the question of that whether these are really fair relationships or these are exploitative ones. You begin from there, and then if you come to the pandemic and you come to migrant workers, it may be a different sort of an issue. But what's a foundational question which arises in the context of migrant workers? If you don't ask that question and you frame it like a topic again, then you're not the sort of takeaway that one wants you to take from this session would not be happening. Literally say, okay, what is the problem? Why am I asking this question? Pen that down, Dikshita, you would be yourself able to answer whether or not it's a good topic to work on. Is there a problem there? If there is a problem, what is that problem? Okay, yeah, Vasanthi, over to you. I just thought, I should say it here because otherwise we keep getting these kinds of questions, and I feel the spirit with which these workshops are being done then starts to lose out in the process.
Yes. Thank you, Professor Danda. Also, for connecting it to the question of how are we teaching labor law, and what is this stranglehold that we have of the legislation. Fortunately for me, because I was teaching it along with you and along with other colleagues within this our law school, which talked about looking at a diverse set of materials, that it came to me that what we're doing with labor law is is actually very, very wrong. I mean, I would go to the extent of saying that there's no point in teaching labor law in the way in which it is regularly taught, because you're missing out the really important questions that need to be asked, the very meaningful questions. Whatever makes it worthwhile, we're leaving out. And I don't think this really happens with other areas of law, at least to my limited extent, whatever I have seen of the other areas of law that we deal with. I don't think any of them get the kind of treatment that labor law does. And so I think it becomes absolutely essential for us to teach labor law very differently, or rather not teach it at all. If you don't want to teach it the way in which you are suggesting that you, or Professor Kannan is suggesting, which is, start with, okay, and this is a question that if you remember that we had started off with, okay, so what is labor? How do we start defining it? Why do all these statutes, which are called labor law statutes, don't even have a beginning of an, even a nodding to say, okay, people, this is labor that you need to engage with. This is the very difficult, I would say it's very difficult for law to engage with the whole question of labor. So perhaps at the initial stage, there was also this belief that all that law can do is perhaps to not criminalize trade union activity and then leave it at that, because I don't think it has the apparatus to deal with it more than that. So if you look at the entire English law of what was known as collective laissez-faire, they said that all you need to do is say that trade unionists don't go to jail, and that you're not going to imprison them for acts against the state and stuff like that, and leave it at that. Beyond that, you don't have the capacity to engage with it. You cannot be as fluid, as dynamic, as radical as the as people who are actually engaged in that work can even be, right? So there is this entire logic to say that a statute only comes in to de-radicalize labor law. And so the minute when you understand that particular logic, then you begin to realize that the way in which the entire labor law edifice in India is built around this idea of it doesn't satisfy anyone. It doesn't satisfy industry because it doesn't see a role for itself there. It doesn't satisfy the working class because they have been completely left out of it. And all you have is the state appropriating to itself a whole range of powers, which it then decides to confer and not confer, exercise, not exercise, according to its whim. So the entire project of labor law in India is a project that aggrandizes state more than anything else. And so for us to go back to the brass tacks is the only way in which we can make sense of what is actually happening out there. And if you don't want law schools and legal curriculum to become these absolute islands, or literally, when I'm using the word island, I'm referring to it as, it's become a very barren and a bare idea, because you're not engaging with what is actually happening out there, and you're staying with a very restricted pool within which you're trying to operate, right? So this is what the government is going to make, and so you're going to try and figure your way out within that without actually going out there and engaging with what's really happening in the field. So as a project, unless this is done in this way, where you engage with what are the normative questions, you engage with what has been the research on labor, not the law, but on labor, or understanding how labor is conceptualized, how these ideas are conceptualized. Without an engagement with that, I think the entire project of labor law is only going to serve a particular end, rather than any useful end. As a law school, that we need to be very conscious of what is the end towards which we are teaching labor law, and that becomes, a very important idea. And there is a way in which it can be taught. I'm not trying to say that it can't be taught, because we've done it. I mean, and we continue to do it, where we're trying to ground it in theory, we're trying to ground it in concepts, we're trying to ground it in a lived reality. So I think it can be done. I think we can take these various illustrations of how it can be done, demonstrate it, and it becomes a much more exciting way to teach labor law, because otherwise it becomes a very dull, dry area of just reading statutes and trying to make sense of it, trying to wrap your head around a statute which itself has no coherence. I mean, there is no conceptual clarity within labor law. You can't hope to find it within the law. You can only hope to find it if you step out of the law. Then what are the concepts, what is it based on, why is it structured in a particular way, makes any sense. Otherwise, it remains a very meaningless exercise. It's like a dog trying to chase its own tail, and it is going around in circles without, really making any useful intervention there at all. So, as far as legal curriculum is concerned, I think what you're suggesting is that the stranglehold that we have, start with the statute, deal with, okay, if we have 300 statutes, we'll deal with two. We don't engage with the remaining 300, and we don't even try to tell them how these 300 figure, is a useless exercise in both ways.
Actually, you're doing nothing. You're neither really saying, okay, you're doing this very comprehensive study of the law, nor is it that you are really understanding, law within a larger context. So I was actually thinking that maybe, I mean, and this has just come to me as I was listening to, and I'm hoping that those of you who would be listening to us, the point that one is trying to make, and I think that's what makes doctoral work or research work rewarding, is because whatever it is, when you are creating a curriculum and you're teaching, whilst you could have a critical perspective, some level of grounding of what exists is also necessary. You can't get out of it. It's like then to say, okay, how you reach that is, you can reach that is from that larger context and sort of say, okay, look at it. This is how you've conceptualized labor. Hence, you are defining workmen in this manner. So it's like you're constantly talking about what is there in the legislation, but you are latching it to other kinds of ideas and saying you need to understand the politics behind this legislation. It just didn't come like this. It came because there were other forces at work. There were other objectives that people, and necessarily the unearthing of these objectives is the subject of research. It feeds into, like then to say, because whatever happens for all of us, remember even the conversation we're having around the labor law book is coming on this count that if you're asking people to teach differently, they turn around and they'll ask you, what do I teach it with? A range of disparate readings doesn't help somebody who's kind of going to be negotiating, who's not spent a lifetime studying it, and who's like said, just been allotted the subject and is asked to teach. If you don't have that level of materials and that kind of writing and research hasn't happened, I mean, I'm sort of really see what happens. And the reason I'm also saying this is that I think for a lot of younger scholars today, doing that doctoral work has become a survival question. It's like, if I want to get into the academy, I need to do a PhD. So then what is the most, what should I say? What's the way in which I can most quickly do it and fulfill that, like check that box so that I am in. The point I want all of us to think in terms of that, to do a PhD like checking box And to do a PhD like that, I am going to make myself into an independent scholar who has a contribution to make in the academy. These are two very different situations. Because when you make yourself an independent scholar, that is when you equip yourself with whatever you see as the power of managements and administrations and universities and whatever. Because that what you put inside you is your biggest protection, not the godfathers and godmothers that you acquire on the way. And it's very often you feel it's my social network which will protect me, but your social network doesn't protect you if you yourself are not confident that I'm so good that I will be able to work out a way in. And that's where I would say, in putting out, you have to do that PhD, it's true, but what kind of a PhD you want to do, I think that's a question only you have to answer. And one of our reasons for doing these workshops is to tell people there is another way. You can still say we don't want to do it this way, but at least it should be a decision with knowledge, not out of ignorance. It should not be that हमें पता ही नहीं था कि और भी तरह से हो सकता है. Sorry, I interrupted you, but I was like, I'm almost making it like some kind of a thinking aloud with you kind of way in which.
Yeah, no, so I agree, and I'm happy that you're making this about. And so for Vita, I don't think I see labor law as not part of what public law is, or how public law is concerned. So, and I think Prof. Siddhanta has also answered it. It's as much a question of legitimacy within labor law, right? To talk about how and why you make labor law, for what purposes, what are the purposes it is serving, are questions that are integral to all public law. And labor law is a very important component of that public law. We don't teach it so much as part of public law, but it's because of the way it's structured. But many of the things that we spoke about in public law, whether about how a certain kind of politics influences what kind of norms arise, or how those norms are intended to meet certain ends, how we're talking about accountability of state, accountability of employers, of people who are benefiting from that labor. I think those are questions which are integral to all branches of law. So if you are able to see public law as a very vibrant component of labor law, and to take further what Professor Danda is saying, that if you do your research in a particular way, then whatever you teach, so even if you are working in a completely different area, if you've touched upon these fundamental ideas, right? This idea that you look for context, you look for theory, you look for concepts in whatever work you're doing, that is a training that is going to be useful to you whatever you do. And I'm going to say that I spent the first 8 years of my life doing labor law before I started looking at public law. And it has changed the way I look at public law. So it has been very useful for me to look at labor law in the way in which we are talking about. It helps you look at other branches of law also very differently. If you hadn't done this, then your own understanding of the public law would not be as much if you don't understand it in this way. So I think the connection is very much there. And Manisha, it's true, it's difficult, but and this is what we've demonstrated at Nalsar, and that somewhere the law schools, and I believe that if you want to do it, and if you find a way in which you can do it, because I also taught statute, it's not like I didn't teach the statute, but you look at the statute in a particular context, it becomes interesting for everyone. It becomes interesting for you, it becomes interesting for your student, there's something meaningful that is coming out of it. They're able to see the connection of labor laws with the other laws. So it is a very valuable exercise. Of course, we have to struggle with it. And of course, we have to find ways and methods and materials to teach it in. But it's very doable. It's worthwhile to do it in that way. And like I said, you do it in labor law, it becomes very evident that that's how you approach the other branches of law, or whatever branch of law that you want to teach. I think it's a very useful exercise, both as a teacher and as a scholar. To be able to formulate your research in this manner, I think will make your research worthwhile, irrespective of which topic you're going to choose. So don't look at my own exposition as only in terms of labor law, which is why in my last slide, I was also trying to bring together the other presentations that we have had. right? That you move beyond the statute, right from what Professor Mustafa was saying, what Professor Danda was saying. You move beyond the statute, you look at the larger society, you locate yourself there before you formulate a problem. I think those are useful whether you're doing labor law research or you're doing other kinds of research.
If I could just add on to what you're saying, Vasanthi, and especially because Manisha made this one comment when she spoke, where she said, how do you promote that kind of interdisciplinarity and intradisciplinarity when all the other practitioners, be it, and especially she referred to judges, that they have a specific perspective by which they look at these issues. So my one point here that I would want you to think about, Manisha, and I think it's important for us as academicians especially to look at our own place within the legal system. Somehow or the other, the way in which the legal system is understood, we believe that, judges and possibly lawyers are the real drivers of the system. For ourselves as the legal academics, as people who do research in it, we are seen as the outliers, people who are virtually, on the margins. And very often a lot of our writing is only recycling what judges and lawyers have said. And possibly because we tend to do that we don't have that kind of, it's not like, see, the basic structure doctrine came in from an academic. It is Conrad's writing which got the Supreme Court of India to pick up that idea and then, sort of implement it. So if you have to decide, what kind of academic you wish to be. You could think of yourself as a Conrad who's kind of contributing to and is being an idea feeder. I mean, whether it's Conrad, it's Tony Blackshield, it's Upendra Bakshi, all of these people at different points of time have influenced the way in which judges have made or thought of the law. So we have to think of where we have to see ourselves as the idea feeders of the system. And we're also the people whose bread and butter doesn't come from the status quo. So if I teach the Industrial Disputes Act in a dramatically different way, I'm not arguing a case in court. So it's not like that somebody is going to throw my client's case out because I did not quote the section correctly. And I spent more time on saying why this section. And it's like, of course, when we're teaching the LLBs, we'll have to constantly also tell them what is the law. But I do think that your internalizing of what is the law is also greater when you teach it along with why is this the law. I at least find it's easier for me to remember what the law is if I know why it is so. So it's a question of like your methodology of teaching and then your own independent thinking. All of us, if I feel that how can I say differently if this is what the Supreme Court is saying? Or how can I say differently if this is what my teacher is saying? So I think it's like both the teacher and the Supreme Court should be questioned. And once we get used to that's why I'm saying do your PhD as, okay, this is getting myself that imprimatur of being an independent scholar. That's my venture. That is if you see it in that manner, then you'd find that, one is willing to stretch oneself, one is willing to take that challenge. Okay, this is about your freedom, your independence, to be your own person. Agar kuch kiya hi nahi hai, so it's very difficult to do. Then you're just mouthing opinions which necessarily are not going to have any credence. Scholarship requires that, you put yourself out there, you take those kinds of risks. I mean, this is just like, I thought that particular sentence was demonstrative of, I think their real dilemma. That if I do this, people are going to tell me, tum kaun, how can you possibly be, you one like Kalka Bacha is trying to tell the Supreme Court or trying to tell other established scholars. But I do think that somewhere all of us have to put ourselves out. So the more deeply you work, you will find yourself having greater confidence in being able to make that statement. I don't at any point of time sever the intellectual from the emotional. And I feel that the emotional somewhere gives you the courage to also do things which are intellectually more challenging, getting out of comfort zone. Because the joy that you get of having discovered something is I mean, I think I did an interview with Upendra Bakshi for his legal education volume that we're bringing out. And one of the things he said the job of a teacher is to take the horse to water. And if the horse drinks it, your job is done. He said, of course, people can still refuse to. It's not like they can't. But, you have this confidence that once they have done it, that intoxication or that addiction that you have got them into to that water sorts you out. You don't have to do anything after that. Your job finishes after that. And I think it's something like that, you do your PhD at that level. It would necessarily mean that you are an independent scholar in your own right. And imagine every PhD we produce, if we want to change the system in this country, then I think it has to come from scholars. And it will only come if you are not checking box, not doing a PhD to check box, but doing it to equip yourself to be an independent scholar. I'm saying this everywhere, but it's like my favorite hobby horse at this point. I'm sorry. Sorry, Vasanthi. I think you had something from Kannan that you had to respond.
No, I think that's what I'm saying. There is no way in the way in which the law engages with questions of labor. There is nothing in the statute that actually speaks to any of the understanding of labor that is coming in from Marxian theory at all. What you have occasionally is some of the judges using some concepts, again, not really the concept of labor as much as a concept of subordination or this idea of, the purpose of the law. But really, that whole understanding of what is labor doesn't figure in any of the statutes, doesn't figure in the interpretation largely. But I think it is our duty to engage with it as we engage with it as labor law scholars, that we have to engage with what are those ideas. But of course, then the second part is, as lawyers, we also need to see how then the law is engaging with that question and what are the ways in which you allow for a more informed engagement of the law, right? So to take in from what Veta was saying about when we talk about public law, we talk about this whole idea of legitimacy, which is also about participation, right? So when we say in labor law, you bring in this idea of participation. You try to address maybe some of the questions of alienation which are arising there, or at least take it on board. You take in the whole business of alienation. But you're right, in terms of how is work understood, how is labor understood. I think there is a lot of work that can be done just in that, just in terms of how it is understood and what you're seeing around you, and why do you find the law really struggling to deal with these forms of work, and why it is so safe and why it's so easy for itself to confine itself to those few questions about working hours and wages, and then we're done, because it really also does not have the kind of apparatus to get into it more deeply. And so there is a need, I would say, a very very felt need for an engagement. Are Indian scholars engaging in it? I would say yes, certainly. Not law scholars, maybe not too many. But I know that, for example, in the whole Street Vendors Association, there were scholars who engaged very, very well with this whole question of, what is it that is involved in the whole business of street vending? How does the law engage with them? What is this question of dignity? And for example, in your topic, the way in which you phrased it tomorrow also, I was very excited to look at this whole business of recognition and redistribution. They have done it with reference to street vending. I think Sharad Bhaumik's work also with reference to street vendors, where he has engaged with some of these questions. So is there work in India? I would say definitely. Is all of it within law schools? Maybe not, but you do have a whole array of social sciences which have engaged with these questions, I think, in a very engaged manner. How much of it? I mean, for example, if you look at the entire report on the report of the National Commission on unorganized workers, unorganized sector, right? And the report that it produced did engage with this whole business of how do we understand labor in India? And there is a lot of research that has happened. I wouldn't say that the research is not there. How do we factor it in? How do we as lawyers engage with it is an ongoing question. But I think the research is there, definitely.
Yeah.
Yeah, Kanan, yeah.
Yes, yes. No, I'm not saying that no research on this. But my only thing is that the way this labor is categorized as a kind of a very objectified thing in the law. And when it is this whole process of objectification takes place in codifying the law, I think the labor, the agony which is there in the labor is lost.
Mm-hmm.
Okay, so I think whether Sharad Bhaumik or there are so many scholars work on social sciences, at least they were trying to go a bit near to that. But the legal scholars who study this labor law just look at as the usual pattern that okay, this many judgments have done on this particular industrial dispute, and these are the many related to wage hike. There are so many things, but the way the very fundamental question is that how labor is understood. No, labor legislation defines it. Okay, there's no need to define it, but how it understands its existence here, and how it is basically objectifying the whole labor, and whether it is when it is objectifying it for them it's mere category. Okay. So that is the basic question one should ask. Why this most of the time even judges are not able to understand this labor. They understand it as a work. Why the so I think most of the time why the especially judges gave the lower court level at least the judges are with the workers, but when you go to the higher level and you see the judges are not with the workers, they are just mostly on the other side. And it is basically because your interpretation of the statute, it is more objectified category. They can't think beyond this. So that's what I was saying, that the labor is missed and it is what you see is work.
Also, Kanan, like when you have a judge who tries to do otherwise, because you haven't really created that kind of jurisprudence and you give that sort of primacy to the legislation, the fact that you're trying to do, you're trying to look at the situation of the worker, or you're looking at the state of labor in how you're trying to interpret the statute. I think Desai got a great amount of pillorying on that count, and there's an entire whole decade after Desai where the Supreme Court of India was only engaged in sort of overruling every one of the decisions that he had made. They were doing nothing else. It is like you did have that kind of, especially like, as there are certain kinds of judgments that he came up with, and the pension one still holds good, wherein you virtually revolutionize the manner in which you're looking at workers' rights. But because it was really not something which is coming in purely from the black letter text of the law, you had a whole range of succeeding judges who displaced what he had done, not by trying to say that, okay, even if this is the context, they just went back to the text and said, literally by the text, he couldn't have done it, and hence this is out. So that dynamics is also worth looking at, why, if we do not sort of have this critical approach in relation to the law, and we look at it as what came in from the legislature and the court as something which is unquestioned, which it is, you can't just question it, you just have to follow it, then any kind of internal rebellions, you could say, also get quelled very fast. I'm just sort of saying this is the other dimension. And that's why it becomes important for us as scholars to constantly keep saying that these are choices that are being made. These are choices made in legislation and choices made in adjudication. And to be saying this is the only way it can be done is not true. But which is why I started out by saying that I wonder, how easy it will be for us to persuade young scholars to start thinking about labor law in this dramatically different way if we teach them labor law. And I mean, I think Manisha was raising a very similar kind of question, that if you teach it in that way, then necessarily you're going to reproduce only that kind of stuff. So, any last questions, comments, concerns from anybody? Okay, I think Vasanthi, I would definitely want to thank you very warmly. And I'm sort of, maybe this is one of the videos we will put out faster, just for this reason, that I think that people should, one, know what is being missed, and two, the other thing also is that I think we had, despite the fact we had a good conversation, which was the basic purpose, okay, it didn't go in the question answer form, but it has got all of us to reflect. And I definitely, in my faculty development program, I think the second one is going to be how to teach labor law. The reworking of labor law, because it's a very, very important area. And it's more also to do with the fact of, I don't think that any research which is divorced from larger social context and what its relevance is going to be is worth doing. And the fact that we are literally having labor and labor law both being slaughtered, it's an important time to sort of really seriously think in terms of what are we doing there? And are we kind of, if we just carry on in the same uncritical manner of providing information, then we are complicit to this whole process. And I do think that's important for us to worry about as educators.
Yes, I was very happy, and I really wanted to do this. It also gave me, a chance to just look at how I think we should be doing labor law research, because we do receive proposals on labor law, and we are constantly trying to tell candidates who send in their proposals that we are missing these elements. And I found it very sad that all the research council meetings, we've had a lot of students who have put in proposals on labor law. None of them have gone through, because these fundamental questions that we expect them to be able to look at have not really been framed. So I was very happy to do this, and I knew that this would go on a platform, and anybody who wants to think about their research will be able to say, okay, I think it's very useful that we need to put it out there, that this is what we expect in a proposal, and then of course expect people to write a proposal around that. So I'm very happy to have done this, and thank you all. Thank you, Kanan, for joining in and giving us those insights.
Thank you.
And thank you, Vetha, Dikshita, and Manisha. I think we had a couple of people who were there before who kind of like stayed till the end of the presentation and then drifted away, but that's fair enough. Like I said to you, that it's for us, the importance of the conversation is more. I mean, even if it meant that we just need to have an inter-se dialogue, it's fine for us. But it's a dialogue we would want to share more widely. Anyone had something to say? I mean, I thought I heard it. No, I think it's someone's microphone catching something else. All right, thank you very much. So see you tomorrow, Kanan.
Yes, see you tomorrow.
Bye.